We had started to discuss contract in Islamic law and looked at the definition of aqd and some of the related aspects. Now, and we started to talk about promise in Islamic law, wa'ad or promise in Islamic law, which is an important topic from which you may have seen that in the tutorials, a lot of questions have come. So it is very vital to understand promise and how it is relevant in contracts in Islamic law. And it's also important because some of us misunderstand promise to be a part of contracts, because promise appears prominently in conventional law, in contracts, to the extent that contracts are defined as promises. I explained to you or mentioned to you that it is not the case in Islamic law. So it is vital to see how significant promises are and what is the status of promise as far as a contract is concerned in Islamic law. Well, now very briefly, I had given you what a promise is, which is the undertaking or expression of a wish to carry out something in the future, which in the form of omission or commission. It could be a promise to do something or to desist from something. But our concern is to see about promises to contract. A person makes a promise to create a contract in the future. I will sell this, or I will buy this, or I will lend, I will guarantee. So at a future point of time, a person expresses his will to create a contract. So I said that we have to look at this from two perspectives or two angles. Since we are discussing in the context of contracts, would such a promise result in legal effect?
Okay.
We know that contracts result in legal effects. So would a promise of this nature result in legal effect? Will that give rise to any legal effect with regard to the entity to which the promise is related, such as subject matter? Or will it result in the creation of rights and obligations on the parties? So will that result in any legal effect? And the second aspect pertains to enforceability of a promise. Would a promise be legally enforceable? Well, with regard to the first, we should understand that unlike contracts, promises do not give rise to legal effects. A promise will not result in legal effect on its own. 94 so far. A promise does not result in legal effect. It will not give rise to any transfer of ownership, for instance. It will not give rise to a person obtaining any claim on another party or right on another party. It will not give rise to legal effects, neither pertaining to any subject matter nor pertaining to the contractors. What we mean by this, I think I started to explain through an example. If a person promises, I will sell this laptop to you on, let's say, 1st of January 2021. I will sell this laptop to you on 1st of January 2021. Now, this promise will not result in any legal effect. Neither at the point of making the promise, creating the promise, nor on the date referred to in the promise. Let's say that he makes this promise today. I will uh, sell this laptop to you, or we can even say I will gift this laptop to you, okay, on 1st of January 2021. So if he makes this promise today, on 26th of October, there is no legal effect, which means that the laptop, it still remains his property and no transfer would be affected in the uh, ownership. With regard to the ownership of the laptop, the previous owner remains the owner. Well, what about 1st of January 2021? When that day finally arrives, will the transfer of ownership result on that day? You see, let's say he's made a promise to gift or promise to sell. There are several aspects to discuss here. I do not want to make this discussion complicated. Let's say that the other party too accepted, you see, because sale is a contract where two parties need to be involved. So in our case, we are talking of a promise to contract. Let's say, for the sake of argument, that the other party too agreed to this promise. So now on 1st of January 2021, based on this promise made today, when that day dawns, will the transfer of ownership happen automatically based on the promise? It will not happen. Even on 1st of January 2021, the laptop will remain the property of the promiser. Based on the promise made alone, there will not be any transfer of ownership. So this means that the promise will not result in any legal effect, neither on the date of promise, nor on the future date referred to in the promise. Promise on its own does not result in legal effect. Now, I want you to understand that we are talking of a promise in this form. I will do this. Our discussion is not a contract related to the future, which is another topic. A contract related to the future is another topic. I am talking about promise, where a person says, I will do this, or I promise to do this. A contract related to the future means a contract is created right now, but it is related to a future point of time. In effect, it will mean that, for example, when a party says, this laptop is hereby sold to you on 1st of January 2021. You see, the contract is created right now. This laptop is hereby sold to you on 1st of January 2021. So instead of relating this contract to the present, the contract is related to a future date, which is referred to as, in this context, future sale, which is another topic. It is not part of promise. It is creation of a contract related to the future. So do not confuse that with this topic. Future sales will be discussed perhaps under sales. In short, future sales with regard to specific identified particularized objects is not permissible in Islamic law. Future sales have their own details and conditions, and where it is possible and where it is not possible. Well, our purpose is to discuss a promise. I will sell this to you. I will lend so much to you. I will guarantee. You see, where the contract wished to be created on a future date is mentioned in the promise. Well, so when this is the case, there will not be any legal effect neither on the date of promise nor on the date referred to in the promise. Well, the second aspect, would this promise be legally enforceable? What does legal enforceability mean? Yes, who can tell me what would legal enforceability mean? Is Madam Siti Noor Fatima here from section 1?
Yes, sir.
Yes, tell me what is meant by legal enforceability.
Maybe both of the parties must have consent.
Yes. Legal enforceability, whether something is enforceable legally, what do you understand from this?
Maybe both of the parties must get consent to the promise.
Give consent? No, legal enforceability. I think even the wording is clear. Whether something is enforceable legally, what does it mean?
Doctor,
Not only give consent. Yes.
I think
Can the
it means
force
that
of law be used to compel the parties to stand by and fulfill whatever that was promised? That is legal enforceability. Can a person be taken to courts to compel him to do what he promised that he will do? Or you see, whether the force of law can be used to make a party to do something, that is legal enforceability. So would the promise be legally enforceable? Are contracts legally enforceable? Yes, Madam Sophia Shakira, are you here?
I'm here.
Yes, are contracts legally enforceable?
Yes.
Contracts are legally enforceable, yes. The whole purpose of creating a contract is
Yes.
to create a legally, legally binding, to create legally binding obligations so that the parties are legally required to fulfill their roles and fulfill the obligations. If a party does not do so, the force of law can be used to compel them to do whatever they have to do. Well, so contracts are legally enforceable. If a person does not fulfill his contractual obligation, he will be violating the law. So he can be enforced legally to carry out and fulfill the obligation created through a contract. Now, would a promise result in an obligation of the same level? That is what we mean by legal enforceability of a promise. Well, now, the position in Islamic law, if it is with regard to promises in general, promises are not legally enforceable. Promises are not legally enforceable. It means that a promise is not at the same level as a contract in creating an obligation on a party. It does not mean that the obligation created through a promise is something light. Promises are supposed to be fulfilled. A promise is expected to be fulfilled, and if a person makes a promise while intending not to fulfill it, now it will be a false promise. At the point of making the promise, he intends that I will not fulfill this promise. It is a false promise, and such a person is it is a sign of a hypocrite to make such a promise, to promise something while not really intending to fulfill it. This is a false promise and severely reprimanded. A person should be truthful when any promise he makes. He must try his utmost to fulfill it. Now, but that does not mean that in all situations, a promise is legally enforceable as well, which means that a person retains a level of choice in whether to fulfill the promise or not, and due to some reason where it is no longer suitable for him, or it could be when it is harmful for him to fulfill the promise, it it is permissible for him not to fulfill it. So the promisee should know that the promise made by the other party is not the same as a contract that results in a contractual obligation, and the other party is not legally required or compelled to fulfill the promise he made in general circumstances or with regard to general promises. But in a limited scope, a limited area, a promise can be legally enforceable. Although, with regard to promises in general, the position of Islamic law is that they are not legally enforceable despite of the high level of importance given to fulfilling them. But in a limited area, a promise can be legally enforceable. The exact scope of enforceable promises is not the same in the schools of Islamic law. The delineating or demarcation of this area where a promise can be legally enforceable, it is described or delineated differently. You can find out details from your references. But briefly speaking, it is when the promise is made in emphatic terms. A promise is made in emphatic terms, or when it is related to a condition. If such and such a thing happens, I will create this contract. Or when this promise causes the other party to incur some expenses or labor or liability. Those promises that are so can be legally enforceable. Subject to details, this is the a brief demarcation of promises which could become legally enforceable. The three situations I mentioned, which is when the promise is made in emphatic terms, and where it is made a condition that if such and such a thing happens, I will fulfill this promise, I will do so. Or when the promise causes the other party to incur some expense or labor or liability, then the promise becomes legally enforceable. The last position is the position of some of the authorities of the Maliki school of Islamic law. One of the four schools of Islamic law, the Maliki school. In that school, the position of some authorities is that a promise that causes the other party to incur some expense or undertake some labor or liability, such a promise is legally enforceable. Now, this position has been relied on promises in the commercial context. Promises made in a commercial context, especially in relation to Islamic banking. So understanding this position is important, especially because some of the leading bodies which provide resolutions pertaining to Islamic banking matters, they have relied on this position of some of the Maliki authorities, which says that a promise that causes the other party to incur some expense or undertake some labor or liability, such a promise would be legally enforceable. Well, so this means that promises in general are not enforceable, but the promises that fall under this limited category or a limited scope, they can be legally enforceable, which means that the promisee or the party to whom the promise was made can legally require the other party, the promiser, to fulfill the promise when it falls under this category. Well, an example can be, you will find examples in your references as well. A person says, let's say, demolish your house. Demolish your house. I will lend you the funds necessary for reconstruction. You see? Or embark on this journey. I will lend you the money necessary for your expenses. Remember that this is what we mean by causing the other party to incur an expense or liability. A misconception that occurs very frequently is that whenever a promisee incurs an expense or undertakes a liability, it is taken as a sign for the promise becoming enforceable. It is not the case. The promiser should have caused that other party to incur that expense or liability. Because we said the position of those authorities whose position is used in the context of, well, I want you to read the Introduction to Islamic Finance of Justice Muhammad Taqi Usmani. I had mentioned it in the guidelines, and it is also mentioned in the course outline, and also, well, some of the questions pertain directly to this issue. So go through Introduction to Islamic Finance, and I have already uploaded it in iTalim, you should have downloaded it. The promise in the context of Murabaha transaction in Islamic financing. So look at the discussion there, it is already there on iTalim. So there you will see that prominent bodies who provide resolutions on Islamic finance related matters, such as the Islamic Fiqh Academy in Jeddah, they have relied on this position, and meaning they have used this position for resolving issues pertaining to Islamic financing, where they have said that promise that causes the other party to incur some expense or undertake labor or liability, such a promise will be enforceable, and they have given certain conditions. So I will not describe these now. You must go through the document, either the writing of Justice Muhammad Taqi Usmani, or you can look at the resolution directly. I think I may have uploaded it on iTalim as well, the resolution of the Islamic Fiqh Academy on promise in the context of Murabaha. So there are some conditions I mentioned. I will ask you during tutorial whether you went through this or not. Well, so when the promise is of that nature, when the promise had caused the other party to incur the labor liability, then the promise becomes enforceable. So understand very well that if a person on his own incurs some labor or liability, or on his own, the promisee on his own incurs some expense, but the promiser did not cause it by alluding to the promisee incurring that expense. So in that case, the promiser will not be liable for that, meaning that promise will not be enforceable. But if the promiser causes the promisee to incur that expense, if you incur this expense, I will create this contract, or I will lend this, or I will buy from this. So if that is the case, such a promise will be legally enforceable. And now, if such a promise is not fulfilled, if the other party, if the promiser refuses to fulfill such a promise, then the promisee can use the force of law to compel him to fulfill the promise. Now, there are certain conditions in this resolution of the Islamic Fiqh Academy, which can be explained while we take up some of the questions in tutorial questions for discussion. One prominent issue is that if the promiser refuses to fulfill his promise, to what extent will he be liable for those expenses incurred? To what extent will he be liable for the expenses incurred by the other party, or for the loss incurred by the other party? So something that you must very clearly understand in this context is that if the promisor is ultimately made liable for the losses incurred by the promisee due to the promisor not fulfilling his promise, remember that the promisor will be liable only for the losses arising directly through his promise. The losses arising directly as a result of his promise, or the losses that were caused directly based on his promise. What is excluded here is that the promisor will never become liable for what is called opportunity cost. Opportunity cost. There is a major variation between some situations in conventional law and Islamic law. The person does not become liable for the opportunity cost which is supposedly incurred by the other party. This refers to a situation that, such as when the promisor makes a promise, such as to say, I will lend this, or I will buy this, based on a request to incur an expense or liability. Now, when he does not fulfill it, he becomes liable to the extent of that promise made only. This we'll explain while we take up the question during tutorial. But he will never become liable for the cost of the lost opportunity, which means that the promisee may not argue, because of your promise, I could not invest my money in better ventures. So because of that, I could not make such and such a profit, which I could have if not for your promise. So you become liable for my lost chance of making that profit as well. You see? The profit he missed to make, the profit that was missed to be realized, that is also taken as a potential loss for the party, and the other party is made liable for it. No, Islamic law does not subscribe to this. In Islamic law, only the actual costs, the actual loss incurred, actual expenses incurred, only these should be compensated for by the promisor, and the promise is of the type that we discussed. Well, so now, so please go through your reference material and find out the position of the authorities of the Maliki school, especially, which refers to the promisor causing loss. What are some of the forms of causing the promisee to incur expense or liability? Because differentiating this from situations where the promisee on his own incurs expenses and liabilities and then tries to ascribe it to the promisor, this must be understood clearly. Well, so the summary is that a promise is in general circumstances not enforceable, but in this limited scope, based on the parameters given in the schools of Islamic law, they can become enforceable. Well, apart from this, if the promise relates to something prohibited, if a promise is made in the context of something prohibited, where the promiser undertakes to do something prohibited in Islamic law, you see, I will invest so much in your prohibited line of activity. You see, for instance, I will invest so much in your gambling business, you see, or any other prohibited venture, then fulfillment of such a promise is unlawful and prohibited. Such a promise is not supposed to be fulfilled because the activity that is mentioned itself in the promise itself is unlawful. And if whatever that is promised is something compulsory in Islamic law, then such a promise in all situations must be fulfilled. So such a promise naturally becomes obligatory and legally enforceable promise. So our discussion was about promises in the context of optional activities, which are neither prohibited nor compulsory. In that domain, the general position is that promises are not enforceable unless if they fall inside the limited scope that we delineated. Well, so in this context, you must go through the material I have uploaded. About 3 documents are there on iTalim, which is the book of Justice Muhammad Taqi Usmani, especially the section pertaining to promise in the context of Murabaha, and also the resolutions of the Islamic Fiqh Academy. And you read about this from your textbooks, Wahba Zuhaili and other books that you are using. Well, so this was a discussion of promise briefly. So after this, we are going to discuss about essential elements of contracts in Islamic law. We'll take several weeks in discussing essential elements of contracts. This was the preamble about the definition of contract and some of the related issues. And now we are going to start essential elements of contracts, which are about the expression of the parties and the contractors and the subject matter. And once we go through these 3, then we can start to discuss about aspects related to intention. Well, now this being the 3rd week, you can start forming your groups for assignment, look at the guidelines and the end of the course outline, and form your groups for assignment, and you can start submitting your assignment topics to me along with the names of groups, because this will require some amendment. So I want you to finalize the assignment topics before the end of the 5th week. Is it someone of you who has sent a message? Well, so we'll wind up today with this, and on Wednesday we'll be starting to discuss essential elements. So please go through this material on promise, which is important, and also come prepared for discussing essential elements and expression on Wednesday. Well, thank you very much.
Thank you, sir.
Thank you, sir.
Thank you, sir.
Thank you,
Thank you,
sir.
sir.
Thank you, sir.
Assalamualaikum.
Thank you, sir.
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 Thank you, sir.